clear on what you mean by that.
So to object on relevancy grounds, whether anyone went into the BP gas station or came out of it. I'm sure there was a lot of visits then.
Respond?
Yeah, I believe it is relevant.
To what?
Well, the people are trying to make the argument that the impound was proper in part because the vehicle was hampering private property, and I'm trying to make it clear that.
Issue.
Hold it. Hold it.
Just following on the.
That's why this is like Groundhog Day. I went through this already with the motion. And you were given, counsel, 2, if not 3 opportunities because you had alleged or made the representation to the court that someone there said the vehicle could stay. And I gave you an opportunity to bring that person before the court. One time you brought what looked like, I guess, an attempt at an affidavit, and the question I had was, that's not the owner. And then we adjourned again because you were going to go get the owner.
Yes, Your Honor.
And then you came back, guess what? No owner. Nobody came down. Nobody said anything. And now you want to argue it here again.
Good afternoon, Amy Reiser, appearing on behalf of the people.
Kyle Murphy, PA379 on behalf of Mr. Philpott, who is present to my right.
All right. All right. This is going to be a waiver.
Yes,
I believe so, Your Honor. Today is the time and date set for the preliminary exam in this matter, and we are ready to proceed to preliminary exam. It's my understanding that the defendant is electing to waive his right to a preliminary exam, and the people would also waive.
All right. Sir, is that a correct statement?
yes,
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. And you understand that you will not have that hearing on this case and that you'll proceed to circuit court for further resolution.
yes.
Preliminary examination having been waived, defendant is bound over on the single count in that case. Mr. Murphy. Circuit Court arraignment, you waive presentation and reading of the information.
Yes, Your Honor.
How does your client plead to that charge?
But the court to enter a plea of not guilty, Your Honor.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea. Pretrial in this matter will be set
August 10th at 1:30 p.m. with Judge O'Brien.
August 10th, 2023, 1:30 before Judge O'Brien.
If I may approach just an information.
Yes. All right, and in this matter, bond will continue. I'm fine. All right, we're ready. Court does call the case. The people of the state of Michigan versus DeMonte Maurice Philpott. That being case 22F1 1571. Counsel, state your appearances.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
Kyle Murphy, PA379 on behalf of Mr. Philpott, who is present to my right.
All right, date and time set for preliminary examination. Are we ready to proceed?
We are, Your Honor.
All right.
People would call Officer Joshua Branch.
Sir, please come forward to be sworn. Guess I'll do it. No, it's okay. You can come up, face me. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, have a seat. Upon having a seat, please state and spell your name for the record.
Joshua Branch, JOSHUABRANCH.
All right, you may inquire.
Thank you, sir. Can you tell the court where it is that you're employed
Pittsfield Township Police Department,
and in what capacity?
I'm a police officer on the road.
And were you working in your capacity as a road patrol officer on October 19th, 2022?
I was.
And were you alone or did you have a partner?
I had a partner that
And who was that?
officer Max.
Okay. And did you have contact with the defendant in this case, DeMonte Maurice Philpott, on that date?
I did.
And what approximate time was it, if you know?
If I remember you called to me around 2:50
AM, okay. And the person that you ultimately identified as DeMonte Philpott, do you see him in the courtroom today?
I did.
And could you tell Judge Simpson what he's wearing and where he's sitting?
Stipulate time, Judge.
All right, so stipulated.
And what was the nature of that contact with the defendant?
The nature of the contact was I ran a license plate of the vehicle that was parked inside the BP parking lot. They came back to if I'm not mistaken, Corporal Maxey had informed me that Demonte had a felony as well out of City Township.
Okay. And what did you do with that information?
That information, we pulled up Demonte Philpott's photo through Secretary of State. Officer Maxey informed me, saying that was him at the vehicle as well.
Okay. And did you see him in the vehicle, outside of the vehicle, if you know?
At the time I observed him, he was outside the vehicle, and as we were pulling up, he was re-entering the vehicle.
Okay. And what was the warrant for?
The warrant was for a CSE.
Criminal sexual conduct?
Yes, ma'am.
Okay. Out of your department?
Yes, ma'am.
Okay. And so what did you do then?
After that, we had approached the vehicle. We asked the person if they were Demonte Philpott, which he identified himself as such.
Okay. And did you take him into custody on the valid warrant?
He did.
And what happened next?
After that, we identified the other passenger inside the vehicle. Found that they also did not have a license and conducted an inventory search of the vehicle prior to impound.
Okay. And I should apologize. Let me back up. I asked if the CSC warrant was valid. Was it in lien?
Yes,
Okay. And you said the passenger did not have a driver's license?
correct.
And did Mr. Philpott have a driver's license?
I do not recall this.
Okay. So you then did what? You said impounded the vehicle?
I performed an inventory search prior to the impound.
Okay. And what, if anything, did you locate during that inventory search?
I located a firearm on the driver's seat of the vehicle, along with suspected narcotics in the door of the driver's door.
Okay. And did you say there was a passenger in the passenger seat? Anybody in the rear of the vehicle?
Nobody in the rear of the passenger.
And where was Mr. Philpott when you took him into custody?
Driver's seat.
And I'm going to show you, did you take the weapon into custody?
I did take proper possession of the weapon. Yes.
What kind of weapon was it?
It was a handgun.
What kind of handgun?
Single stack from my recollection.
And the suspected narcotics, were those also taken into custody? Okay. And were they tested? And did they test positive for cocaine?
Corporal Maxey did inform me that they tested positive. Yes.
Okay. With a true narc test?
Yes.
And did he do that in front of you?
Yes.
Okay. I'm going to show you what's been marked as People's Proposed Exhibit 1 and 2 and ask if you recognize these photographs.
I do.
And can you tell the court and for the record in People's Proposed Exhibit 1, what are those photographs of?
Photographs of the vehicle, 2 photos, one from the driver's side, rear part of the vehicle, one of the front driver's seat, 1 photo of 3 scales that were recovered, and 1 of the suspected narcotics at the time.
Okay. And are those a fair and accurate representation of how those items appear on the night of October 19th, 2022, or early morning hours?
Yes.
Okay. And in Exhibit 2?
Exhibit 2 is a black handgun firearm. The specifics is going to be an FN 503.
Okay. And was that loaded?
Yes, that was one of the chamber.
Okay. I would move for the admission of Exhibit 3.
Any objection or voir dire?
Oh, that's for the purposes of preliminary exam.
Exhibit 3 is admitted.
And did you run Mr. Philpott's criminal history
I did.
and determine that he was ineligible to possess that firearm?
Yes.
I'm going to show you what's been marked as Exhibits 3, 4, and 5 and ask if you can identify those for the record.
Yeah, one. That's what I thought. Ms. Reiser, you said you asked for the admission of Exhibit 3, and I thought I had lost track and was going to cut with my recorder, but you meant Exhibits 1 and 2.
I meant Exhibit 1 and 2.
Yes, okay, so Exhibits 1 and 2 are admitted. I have not yet admitted 3.
And I'm showing him proposed 3, 4, and 5.
5, got it.
And do you recognize Exhibits 3, 4, and 5 to be certified convictions of Mr. Philpott?
I do.
I would move for the admission of Exhibits 3, 4, and 5.
Any objection of what is? Exhibits 3, 4, and 5 are admitted.
And I'm going to show you People's Proposed Exhibit 6. I labeled this number 7. I don't know where 6 is.
Okay.
I'm going to approach
okay.
and show you 7 and ask
7.
if you recognize this. There is no 6. That were recovered from the driver's side of the vehicle?
Yes.
Okay. Did you remove the ammunition from the chamber and make the gun safe?
I did.
Okay, thank you. I don't have any other questions. The location where you, I do have another question. The location where you had contact with the defendant at 2:50 a.m. on October 19th, 2022, is that located within Pittsfield Township, Washtenaw County?
It is.
You said it was the BP gas station?
Yes.
What's the address?
Call.
Is that at Washtenaw Avenue in Gulfside? Okay, thank you. I don't have any other questions.
And so we're clear, it's on the west side of Gulfside, which is Pittsfield Township. The court can take judicial notice of that.
Okay, thank you.
Did you wish Exhibit 7 admitted?
Yes, please.
Okay, no objection. Exhibit 7 is it? Exhibit 7 is admitted. Cross-examination.
Officer Branch, you talked about making a decision to impound the defendant's vehicle. Why did you do that?
What's that?
Why did you choose to impound it?
I was informed by my training officer at the time that pound the vehicle
Do you know why?
based on policy and some other things.
Is that what he told you that day?
I'm not mistaken.
Your testimony here today is that he told you that you were going to impound it based on a policy?
From my understanding, it was by policy.
That night, did you tell Mr. Philpott that you were not going to impound the car before later changing your mind?
What I told him, if my memory recalls correctly, I told him that I would not get my own driver.
And when you told him that you weren't going to impound it, were you telling him the truth?
From my point of view at the time, yeah.
Yeah, that's all I'm asking at the time. Very good. Time of, well, before you decided to impound the vehicle, did you enter the BP gas station?
We did.
You entered the inside? The convenience store, for lack of a better description?
No, not the convenience portion, no.
Did you speak to the clerk inside the gas station?
No,
Are you aware that any other officer spoke to the clerk inside the gas station?
I am not aware, no.
Are you aware of whether or not the clerk came outside of the gas station?
No.
Surprised you to find out that there was body camera footage of Officer Maxey suggesting that you impound the vehicle in order to search for drugs?
Okay. I think we need to stop right this second because I had 3 or 4 hearings on this, counsel.
Yes.
And I'll allow any attorney to ask what questions they want to ask. But there certainly is video of it. This court specifically looked at that video. You did the same thing during that hearing in suggesting or really informing the court initially, prior to receiving the whole video, that this officer said that he was going to impound it, then that the other officer changed his mind. When point of fact, that's not what happened at all.
Respectfully, Your Honor, I disagree.
No, you can respectfully disagree. Play the video. Let's play the video because the video is clear. This officer was in training. The questions were specifically asked of this officer. He makes an assessment. His field training officer says, think about this, and this. The whole scenario that they're going through is a field training officer training another officer. It's not the suggestion and this other stuff. I'm not going to let you pollute the record with things that are just wrong. So if you want to play the video, counsel, play the video.
I'd like to
But
play the video, Your Honor.
play it now then. Play it now and then ask the questions. Because you attempted to try to mislead the court before. Play the video and then ask your questions.
Counselor. Judge, I believe it was Ms. Kirby who played the video at our last hearing. And for that reason, I have not hooked up to this particular system. And I wonder if that may be.
All you need is a cord and a player on your computer. You can hook right into the system. It's not a problem.
Very good, Judge. Your Honor, I do have 2 additional questions before
Go for
we
it.
play the video.
As long as they're fair.
Officer, how long have you been employed by Pittsfield Township?
But Pittsfield since last August.
Was that your first job as a police officer?
No,
Where else did you work?
Detroit.
How long did you work there?
3.5 years ago.
Did you work anywhere else before that? Okay. So how long have you been a police officer in total?
At this time, it's coming up to a little around 4.5 years.
4.5 years. Did you undergo training as a Detroit police officer? Did you complete the MCOLS program before becoming an officer? And did you were you undergoing training at the time of this arrest? Very good. Your Honor, can we take a brief recess while we try to figure out how to play this video?
We're staying in recess.
Thank you.
All right. Where are we? We're ready to play.
I do have the video worked out. Sister counsel here was kind enough to load it up so that it can be played on the court's monitors. With the court's permission, I would like to play that video unabated for at least the first 10 minutes, but as long into the video as Your Honor would.
Well, whatever you need.
Just for the record, Judge, it's 46 minutes in total.
Oh, I know. I watched the whole video before.
Willing to watch it with you, Judge.
Well, I already watched it once. It's like a rerun. But however much of it you think you need to play, I'm just saying that the real interaction occurs, and I don't know the timing, but when actually there were the 3 folks there, and the field training officer is talking to this officer. So whatever point that's at, you can back up a little bit from that, but run it through because you see the context upon which all of these statements are being made.
Okay, so for the record, I'm playing Pittsfield Township 22-13689. This will be the body cam of Officer Tyler Maxey.
All right.
Or maybe.
You got it. You got it?
Mm-hmm.
Okay. Thank you, ma'am. Yeah, your laptop controls volume. A little down, a little lower.
When this case work. For assault. The Monte Philpott, correct? Yes. So, assault. Okay. Yeah. So, that's your last like, contact you or you call me. Okay, we'll look it up in the car, we'll show you. Who's passenger? That's one girl. Okay. Who's client? Okay. Does she have a driver's license? Okay, that's what alright, I'm gonna check you and he's gonna have a seat and I'll go talk to her and see if she can get a car, okay? I'll let them know. I wanna go in this fine. So, you guys don't want first arrest. I'm gonna go to life and out of jail. Do you have a driver's license to drive the car?
I don't know if it's like the one month.
Okay. Well, I'm just trying to figure out what we're gonna do with the car.
Okay.
So, that's the thing.
I don't have a license. I got a permit, I take my license personally, and I told them that I take in 60 kilometers.
Okay, so you have that, yeah.
Bless you.
I mean, I gotta figure out what's going on here, but I don't know. So, yeah. Just, hold on for now. So felony for sex assault on Pittsfield, they put it in July this year. She said that you found it. Oh, that's not nice. So what do we need to do now? So what we need to do. Dispatch on some attic and then link away with but I dispatch needs to know that we have and that they need to tell us whether or not the adjustment forward. That's in there. And I talked about the guy away a couple weeks ago, and he told me that he's been looking for him. He was in school now. So, okay. We'll confirm that your warrant is valid, and it's not valid, and reject it. So just checking there. CSC warrant bus. Like, what would you? Right. So we're.
So there's two options that we can do. You can either try to do the plan. Or otherwise, we can plan.
I understand, but either meeting or make, well, that's what. That way, there's anything in there. Good better. Yeah. So he's gonna go to Washington. Yeah. We're gonna check this, that way if officer automatically finds someone in the car that belongs to you. If, you're sitting with a gun, we can deal with that, but if it's just a taco. So yeah, we can have this investigation, but he does have one. That way. Right now, so because there was a medical and detain, that's he doesn't mean you're going to jail. But just because there was that pistol in the car, we're gonna do a little more investigating, and just maybe feel uncomfortable if you're anything else and then could have done otherwise. Do you have anything on your components? You know, are you okay with me just going straight up? I mean,
Your Honor, if the court's satisfied.
I am. I'm satisfied. I mean, wherever you want to stop it, I'm good.
Mr. Counsel, I think we're ready for the moment.
All right, you may continue your question.
Officer Branch, was it your testimony earlier that you impounded the car pursuant to a policy?
Yeah.
Do you know what that policy is?
Off the top of my head right now,
Okay. Would you give me your recollection at the time of what you believe the policy was?
at the time, from my recollection, it was to impound the vehicle, but a lot of businesses, transactions, or if it's illegal parked at the time.
And that was your understanding at the time? Okay. Were you able to hear what was said in the video?
Hardly, but yes.
Okay. If it's necessary, I don't mind going back to the pertinent points. So please let me know if that's necessary. Okay. Were you able to hear yourself say, or did you say to the defendant that there were two options on what to do with the vehicle before you made the decision to impound? Do you recall what those two options were?
We want to find someone to drive the vehicle, and the other passenger was not licensed, or we would impound the vehicle.
Can we go back and play that portion of the video, please? It's going to be...
Am I just hearing the same motion again?
Your Honor, I'm trying to get the testimony from the gentleman here.
I understand what you're doing. I'm asking you a question that you'll answer. Am I just hearing your motion again?
No, Your Honor, I don't intend to make the same motion again.
Well, you're going to have to speed this along, because I mean, this sounds, it sounds like the same thing. If you want to raise your Fourth Amendment argument in circuit court, you may do so. But my issue here is going to be whether or not there's probable cause to believe that a crime was committed and whether or not this defendant did that. That's the only thing I'm here to decide right at this point in time. And it seems like you're just going through your motion, which I've already denied after 6 appearances before.
Your Honor, I'm just trying to make sure that we have testimony of what...
Which could have been done with the motion, which is why everybody was here. And so that's what I'm asking. Am I just hearing the motion?
No, Your Honor. At the time, we had stipulation from the people as to what was said. We're asking now to try to discern the intent of the officer at the time, which we can't get alone from that stipulation.
But intent is not an issue I decide at this stage, counsel, is what I'm getting at.
No, Your
If
Honor.
it comes down that it's a question of intent, it gets bound over because that's a question of fact for the jury. It wouldn't be something I could decide. So why am I here is what I'm asking. If that's the issue, the intent of what this officer did, then we might as well just stop this now because I can't decide that. You should know that.
Yes, Your Honor, but the testimony is still necessary for us if we choose to make the motion based on what Officer Branch says. We choose to renew that motion based on what he says later in circuit court.
Then you'll have the opportunity during the motion. I mean, play it again. I guess we'll just be here all night listening to the same thing over and over.
So there's two options that we can do. You can either try to so that we're license or we can park it. So you can try to get around.
Thank you so much. I asked you for what, if you recall the two options that you gave. I just replayed the video where I believe you were making those statements, correct? Do you recall what those two options were?
I can hear it a little clearer now, but the other option was to park the vehicle.
Could you state what both of them are?
Yeah, the first option was to find another driver, since the passenger was not licensed, or to park the vehicle.
Thank you. And at some point, did you decide to impound the vehicle?
After council, I have to go. Yes.
Were you able to hear on the video? Do you recall what your training officer said to you that caused you to create a third option or to defer from the two options that you said?
Sustained.
I'll rephrase.
Sustained.
I'll rephrase, Your Honor. You hear Officer Maxey suggest that you impound the vehicle.
Yes.
Did you hear the words that surrounded that?
Based on prior history. Yes.
Are you saying that you can infer what he said based on your prior history with him? I'm not sure I understand your answer.
No, I'm here based on prior history of narcotic trafficking.
Okay. And is that the statement that caused you to decide to impound the vehicle?
No.
Why did you change your mind?
I'm changing my minutes. The FTO must be based on his training and experience on what I should be doing in that case.
What other training and experience did he give you from the time you made those suggestions to the time you decided to impound, other than the statement we just addressed?
The statement alone is not necessarily what made me change my mind. It's my trust in my FTO.
Okay. How long have you been training with Officer Maxey?
I've trained with Corporal Maxey, I believe only that day.
Did you do what you were told?
Yes.
Did Officer Maxey ever ask you to do things that you refused to do?
No.
Did he ever suggest to you conduct in order to test you?
Not that.
Did he ever ask you to do things or suggest that you take a course of action that you knew to be unlawful?
Not once.
Very good. No further questions, Your Honor.
Any redirect?
Officer Branch, Corporal Maxey was training you?
Yes.
It appeared in that video he was showing you how to use what's that computer system called in the car?
The computer system part is the lead system.
And was he showing you how to use that?
No, he was advising me on something that's done with Pittsfield that was not done with my previous department.
Okay, so some different policies and procedures.
Correct.
Okay. And did he sit with you in the car and confirm that the defendant had a valid warrant
Yes.
before taking the next step of action?
Yes.
Okay. And Officer Maxey spoke with the passenger and determined she did not have a valid driver's license.
Correct.
Okay. And so it sounded like in that video, he said, "What would you do?" Is that correct? And you indicated she doesn't have a driver's license, so we can't let her take the car.
Correct.
And your second thought or option was to leave the car parked.
Yes.
Okay, and there was a third option suggested to you by your FTO.
Correct.
Okay. And in terms of leaving the car parked, could you leave it parked in a private facility, in a private business?
It was legally part of the authorization of the employees there.
Okay. And what about your policy at Pittsfield? Were you aware of that?
I was aware of the majority of the policy at the time. From my recollection now, and that is going to be slightly.
Okay. So you have to have permission from your command to leave a vehicle parked on private property. And did you have that? Okay. And the impound was done incident to the arrest of the defendant
Correct.
after you confirmed his valid warrant. Is that correct?
Correct.
Okay. And then the vehicle was impounded.
Yes.
And you inventoried it?
Yes.
Is that pursuant to policy?
Yes.
Okay. And what, if anything, did you locate during that impound?
I located a plunger for handgun along with a suspended cut.
Thank you. I don't have any other questions.
Just have one brief follow-up, Your Honor.
Sure.
Officer Branch, I appreciate this. Would you just clarify something? I asked you about whether or not anyone went into the BP gas station, you, other officers, whether you're aware of it. I believe it was your testimony just now that you weren't aware that the vehicle had permission to be at that private property.
Right.
Did you have any reason to believe that it didn't?
Where it was parked at the time.
I'm sorry?
Parked at the time, the vehicle did not stay there.
Why?
Pump which in place. Transaction.
Did you, I'm sorry, I thought it was your testimony that nobody went into the BP gas station, nobody came out of the BP gas station. So I'm unclear on what you mean by that.
So to object on relevancy grounds, whether anyone went into the BP gas station or came out of it? I'm sure there was a lot of business then.
Respond
Yeah, I believe it is relevant.
to what?
Well, the people are trying to make the argument that the impound was proper in part because the vehicle was hampering private property. And I'm trying to make
So
it clear
this
that.
issue.
Hold it, whoa. Hold it.
Just following on the.
That's why this is like Groundhog Day. I went through this already with the motion. And you were given, counsel, 2, if not 3 opportunities because you had alleged or made the representation to the court that someone there said the vehicle could stay. And I gave you an opportunity to bring that person before the court. One time you brought what looked like, I guess, an attempt at an affidavit, and the question I had was, that's not the owner. And then we adjourned again because you were going to go get the owner.
Yes, Your Honor.
And then you came back, guess what? No owner. Nobody came down. Nobody said anything. And now you want to argue it here again.
No, Your Honor. I'm trying to get testimony about whether or not they were told that there was no permission to remain there or whether they decided it for themselves. I'm satisfied with the answers Officer Branch has given. They answer that question.
Are we done then?
Yes, Your Honor.
Anything else, Ms. Reiser, from this
No,
witness?
Your Honor.
You may step down. Thank you, MC. Any other witnesses for the people?
No.
No?
No, I don't have any other witnesses, John. I would make an amendment to count 2 and count 3 with the additional convictions that have been mentioned, the controlled substance delivery, manufacture less than 50 grams, and the police officer flee and elude. I would just add those both to the felon in possession of a firearm and the ammunition.
Gotcha.
Possession.
Any objection to that?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Motion?
People would move for bind over on count 1 through 4 contained within the felony information. I believe that the testimony of Officer Grant is sufficient to make a probable cause finding that the defendant did carry a dangerous weapon, to wit, a handgun, whether concealed or though otherwise in a vehicle operated or occupied by the defendant, the Ford vehicle that was shown in the video. And 2, that he is a firearm possession by a felon, that he did possess, transport, or carry a firearm while ineligible to do so because he or she had been convicted of possession of cocaine or other narcotic, controlled substance delivery, manufactured less than 50 grams, and or police officer fleeing in a low third degree. And count 3, that he did possess, transport, and carry ammunition when ineligible to do so, based on the officer's testimony that it was loaded with one in the chamber, that he was ineligible also to possess, transport, or carry the ammunition because he had been convicted of the 3 listed felony convictions in Exhibit 3, 4, and 5, and that he did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine.
Response.
Your Honor, just for the record, we renew our motion that evidence in this case should be suppressed
How do you do that?
Today.
How, give me your argument then. I mean, I don't even know how you're raising that motion again. I'm at the preliminary examination. You already have raised the motion. You then supplemented the motion.
Yes, Your Honor.
I mean, if you want me to go through the entire record that I've been through this case, and now you're renewing that motion again at the district court stage at exam?
Yes, Your Honor.
Give me your authority for doing that, counsel, because you're playing by a different set of rules that don't apply.
Just heard-
Give me your authority to raise it at this proceeding. Right now. Right now. If you need to take a break to find the rule, you find the rule. Otherwise, yep, you take your break, find the rule. Court will stand in recess. All right, we're back on the record in the case of the People versus DeMonte Philpott.
Kyle Murphy, PA 3879, on behalf of the defendant, Mr. Philpott.
Amy Reiser again on behalf of the people, Your Honor.
Your Honor, the court had asked for authority in which to make a motion or renew a motion to suppress evidence.
At preliminary exam.
Yes, Your Honor. And all I can point the court to is 6.508, particularly B, which allows the court to make a decision that would otherwise require an evidentiary hearing on its own. And it does specifically list, quote, the expanded record. In this case, Your Honor, the record, although the court may not be satisfied in the way the record was expanded, we do have an expanded record today based on Officer Branch's testimony. For that reason, I'd like the court to consider Officer Branch's testimony.
Okay, I will consider Officer Branch's testimony with regard to the motion to suppress, which was previously raised. Taking that into consideration with the entirety of the other circumstances in which the motion was raised and the evidence received and argument received at that time, the motion to suppress is again denied.
Thank you.
And Your Honor,
Anything else?
no, just making my motion for bind over.
All right. Anything else in response?
No, Judge.
Court has heard the testimony in this case, and with reference to counts 1, amended count 2, amended count 3, and count 4, the court would rule that the people have indeed sustained their burden of showing that the defendant committed these offenses and that these offenses were committed, that this defendant committed those offenses. Therefore, the defendant is bound to overstand trial on all 4 counts. Counsel, as to the circuit court arraignment, do you waive presentation of the information and its reading?
Yes, Your Honor.
And how does your client plead?
I'd like the court to enter a plea of not guilty at this time. Your Honor.
Defendant waiving presentation and reading of the information. Court will enter a not guilty plea as to all 4 counts. Pretrial in this matter will be set for
August 10th at 1:30 p.m. with Judge O'Brien.
August 10th, 2023, 1:30, before Judge O'Brien.